Is it ever okay to discuss the details of your lawsuit with a treating physician? Is that ever okay? You want to know the answer? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The short answer is no, it is not okay. And I'll tell you why. During the course of your lawsuit, in all likelihood, you're going to be seen and treated by doctors who are different than the doctor or physicians who treated you in the past, whom you believe caused you harm and injury. Now, you might encounter a very sympathetic or empathetic doctor who now gets you to open up and to talk about all the things that are bothering you, not just physically and emotionally, but you tell him voluntarily that you have gone ahead and brought a lawsuit against your prior doctor. Now, the doctor understands, he feels sympathetic, and he begins to ask you questions about your strategy and about what claims you are making against your prior doctor. And now you begin to trust this particular physician, this subsequent treating doctor. And now you begin to tell him details of your case. And you disclose to him certain information about your case, specifically information that you learned from your attorney concerning what your expert had to say about your case. Now, your doctor, being the nice, kind physician that he is, not only recorded all of the complaints that you were making about your physical condition, the doctor promptly and properly recorded all of the details about the issues you were having mentally and psychologically. And then, after formulating a treatment plan, the doctor continued on documenting information about your ongoing conversation with him. And among that documentation, the doctor happened to write details of what you were telling him. He was recording in his handwriting the things that you were telling him about the details of your lawsuit. Patient indicates she has now brought a lawsuit against her prior physician. Patient now claims X, Y, and Z against doctor number one. Patient now says that her attorney told her A, B, and C. Patient now says that her attorney's expert doesn't think that there's a great case. Now, what about that? What happens in that instance if this doctor, this loving, caring, subsequent treating doctor, in the course of their casual conversation, makes notes about this patient's ongoing lawsuit and the details of her discussion with her attorney, which, by the way, are supposed to be confidential. Conversations between you and your attorney are, in fact, privileged and confidential. That means no one can learn the details of that information, except if you, the patient, you, the injured victim, go ahead and start disclosing them to other people. So now, if you go ahead and disclose that information to a doctor who is now treating you, that person, now, the information that that person has learned, all that information is discoverable. So if the defense attorney were to go ahead and learn that the doctor now had information about certain details of your case that they were not privy to, they could now do an end run around the privilege and around this confidential nature of your case and conversations you had with your attorney, and now go straight to the doctor and say, hey doctor, can you tell me what your patient said to you about this particular thing? Can you tell me what Mrs. Jones said concerning her lawsuit and what her attorney told her and what he thinks about their expert opinion? Can you share that with me? If your treating doctor has gone ahead and documented those things during the course of treating you, well, my friend, you have a big, big problem. Why? Because the doctor's records will be requested from the defense attorney. They have every right to see all of your treating records. So not only do we have to give them copies of whatever records we obtain from your treating doctors, but we also have to give them permission slips called HIPAA authorizations so that they can go ahead and send them off to the doctor and get them directly from the doctor's office. So what do you think is going to happen if the doctor's office records contain notations about the details that you shared with your treating doctor concerning your lawsuit and concerns that your expert had? Do you think that's discoverable? The answer is 100% absolutely yes. It is discoverable. In that instance, What you have done now is disclose confidential information that is discoverable to the defense, and that could sink your case. It could ruin negotiations. It could destroy the value of your case. Why? Because you shared with your treating doctor things that you never ever should have discussed with him. Information about the details of your case should never be disclosed or discussed with anyone except your attorney. And this is one of the precise reasons why. So why do I share this quick information with you? I share it with you to open your eyes and help you understand how these types of cases work in the state of New York. And I realize you're likely watching this because you want to see the beautiful beach. No, I realize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.